is Gail Pendleton. While Patricia was chatting with you, I put a little note in the chat box for those of you who are new to this system. Please feel free to ask us questions during the presentation, especially we will get to any clarifying questions you have, like if we use phrases you don't know what we're talking about, or we're mumbled or something, let us know. We are hoping to have plenty of time at the end to get to your questions. I did want to do a little disclaimer at the beginning. As you can see, this is actually an advanced training. We haven't done a lot of advanced trainings for grantees yet this past couple of years. And so we did do a whole lot of basic ones. So if this seems like it's a little too advanced for you as you're listening for it, all of the recordings from those prior trainings we've done for OVW, as well as recordings from our trainings for private practitioners, a separate membership pool we have, are available for free on our website, which I think you can access through that web link there, Asista. And so apologize in advance if this is a little too advanced for you. We hope you'll still get something out of it. And for those of you who've been doing U-Visas for a while, that's really designed for you. And we have proposed a series of, I think it's 6 more webinars we're going to do for the rest of the year for you all that are going to be on intermediate and advanced topics as well. So today I have with me Cecilia Friedman-Levin, who is our Senior Policy Counsel. And
hello, everyone.
The goal, good, you sound good, Cecilia. That's good. The goals of this webinar are to identify and address possible problems to avoid requests for evidence, which is what RFE stands for, and avoid and respond to denials or possible denials. Help you frame persuasive responses to RFEs and to denials or intended denials, and identify other steps you may need to take to protect your survivor clients if you're already working with that population, which we hope you are. So, Cecilia, I will run the slides unless and until you want to take over. I think either of us can do it. So the first thing we're going to do is Cecilia is going to run, she's the tech savvy one in our office. She's going to run a couple polls to get your feedback on what you're experiencing, some of these common questions we have. And I will move it to the first poll for you to run, Cecilia.
Hello, everybody. So we're just going to go through some common issues that you might experience in RFEs. And we're going to start with something that happens on, fairly regularly. And maybe you can kind of show us by your virtual hands whether or not you have received an RFE or a request for information that you already gave them. Can you raise your hand? And so how would you respond to that? Do you just respond with a copy of the birth certificate? Do you go to the hotline and say, here, I already gave it to you? Would you contact the hotline and just wait for them to say what to do, or would you do all of the above? And if we could move the slide, or no, actually, no, I can see it. You contact the hotline. Would you do everything? What would you do? Okay,
Yeah,
this is great.
Just so you know, Cecilia, we're putting the poll is kind of sitting in front of the slide because the other option was to put it in the chat. And then we can't see what they're asking. So, okay.
No, that makes sense. That makes sense. I just have to scroll down. Okay.
You want me to move the slide?
So there are 93. So there's 93 of you, and we only have about 40 of you replying. So I'm going to give you another minute with how you would respond to this.
And while she's doing it, we'll give you one of our basic practice pointers on the hotline, which is that one of the jobs we do for all of you is intervene with the decision makers at Citizenship and Immigration Services who do these cases. And so it's better for us to be able to do that if you communicate with the special hotlines by email, because then we have in writing both what you're asking for and what they say back to you. I know some of you use the phone, and of course that's fine for you, but it makes it harder for us to help you if you run into problems.
Right, so most of you have said A, and this is actually what we would recommend you. There was once a time when the hotline might have been able to resolve this issue for you, but just given the backlog and given the processing times, it is far easier just to respond to the RFE with what it is that they're asking. And in the cover letter, you can say, yes, this is that I gave it to you previously. Please check your submission. And you can contact the hotline to make sure that they received it, but generally it is much easier just to give them what they're requesting. And we will be able to share the email for the hotline. There are 3 emails for the hotline. One is for VAWA, the other one is for U&T visa cases, and there is another one for domestic violence-based 751 waivers at the Vermont Service Center. So as we go, we'll look up those email addresses and make sure that we share them in the chat box. All right,
I
next
just
slide,
did
please.
the U&T visa ones, but if people want the other ones, let us know.
Okay, that's something. Thank you, Gail. Let's go to the next slide, please. Okay, now we get an RFE saying that our client made a fraudulent statement at the border, and your client says that nothing like that ever happened. What would you do? Would you FOIA CBP, the Customs and Border Patrol? Would you do a FOIA to OBIM?
What's
which
OBIM?
stands for is the Office of Biometric Information, Biometric Identity Management. Or would you explain in detail in the client's declaration, or would you do everything, all of these things?
We do have another category for the creative ones amongst you.
Oh, yes, and we have other. Would you do something, and if you do choose other, put it in the chat box what it is that you would do, because we are always looking for new and creative strategies.
I'll get the VAWA hotline for him. I don't have the 751, so maybe when I'm talking, you can do that one.
It is in the, it's in our latest practice manual, or the practice advisory from Vermont. So I can make sure that people get that.
Oh, okay, good. That's probably in their materials already, right?
Mm-hmm. Okay, so we have 23% of you saying that you would do a FOIA, the Customs and Border Patrol. You would, and we have 66% of you so that you would do all of these things. And I think that you would want to make sure, so the FOIA to Office of Biometrics to OBIM is related to what might have happened at the border. And so you can request a FOIA to OBIM using the form that you typically would. And so you can kind of get both of them to compare one against the other. And I'm going to put in the chat box the list to the ILRC FOIA advisory, which goes into more detail about all the different types of FOIA. But I would make sure that you get all the information that's at your disposal. And then from there, explain in detail in your client declaration the circumstances in which she supports her claim that there was no false statement made. But again, it's just a very good idea to make sure that you get information in there.
So on the FOIA, Cecilia, we've had this question recently. Do you think that doing a FOIA puts you on Immigration and Customs Enforcement's radar screen?
I have not heard as much that just by virtue of filing a FOIA that would trigger anything. Folks know to the contrary. I'd be very interested in hearing, but I haven't heard anything to that effect yet. Okay. So I agree with the 68% of you that I would do everything and see what sticks to the wall. Let's go to the next slide, please. You have just filed for a U adjustment of status case, and you receive an RFE asking for police reports and charging documents for an assault arrest, but your client was never charged or convicted. What would you do? Would you provide a police report and explain what? And let's assume that we are in a jurisdiction where a police report might be available, because I know in many jurisdictions that you just simply can't get it, which kind of closes the question. But that would make for a far less interesting webinar. So why don't we assume that the police report is available, and what do we do with it? There was no charge, there was no conviction. Do you provide the police report and explain why it's not material or relevant? do you not provide the police report and explain why it's not material or relevant? Or would you do something else? Or maybe if you do other, maybe you can kind of include that like it depends. So if you do choose other, please let us know why other for the two of you who have said as much. We'll get folks
Carly
to
and
that.
Edna. Carly and Edna are two
Mhm.
of our most advanced practitioners.
That you'd want to make it, exactly. So Carly wants to see what she's working with, which I don't blame her. You know, what does the police report say? And I think that that is something that actually matters. Is it hugely prejudicial towards your client, or does it have information that is not particularly damaging? So Jess, if others have folks to say, other thoughts on what they would do?
So, and what would you do if it is damaging? How would you do? Don't provide it and explain why not it's material or relevant, I assume?
I'm having a hard time hearing you, Gail.
Okay. I have no idea where the microphone is on this thing. Can you hear me better now? This is
Yeah, you're
it.
breaking up. Exactly. So just, go the other way to provide proof of no conviction or no charge and explain why it isn't relevant. And so I think this is one of those emerging issues that we're seeing out of the Vermont Service Center. And what they're saying in cases like this is that it doesn't necessarily go towards any issue of inadmissibility, but rather that they want to see this document for purposes of discretion. And so I think this is something that we are seeing as an emerging issue coming out of Vermont Service Center and asking for this information. And from there, I think that there's a determination that might be made. So I don't have the right answer to this. I think that some want to say, listen, this isn't relevant. There's no charge. There's no conviction. I'm submitting a document that is highly prejudicial or relies on multiple levels of hearsay, is not subject to cross-examination, and so should not be considered in your decision. But there are people who kind of do go the other way, and I think that you have to be prepared for if there's circumstances where there was an arrest but no conviction, or even if there was a conviction, that they might want to come back and see the police report. We're also seeing this in the context recently with juvenile offenses. And I think that we really need to be careful on what is happening in those situations and in what jurisdiction that we're in, because in many jurisdictions it might be unlawful to hand it over. So I think that we want to make sure that we're just kind of aware of this as an emerging issue and amazing trend. And again, I think it's a case-by-case determination, but I think it is problematic to, especially if there is a document that is not being subject to cross-examination, that there might be some due process concerns. So I am interested in your thoughts and what you think about this as an emerging issue, because people are dealing with this. And so, again, I don't have the answer, but interesting what you think you would do. All right. Well, while you're typing and while you're plotting on that question, we are going to move on to our next slide. So we are on the wait list. Congratulations to you and your client for being on the wait list and have been recently convicted of shoplifting. What do? This happened just now. Do you put a 192 in right away? Do you wait a hot minute to allow the client to gain some equity? Or do you just kind of wait and see if you get RFEs on it, because they're not going to open the file for a little bit? So what would you do? And actually, now that I'm thinking about it, that if you want to think about the processing times of the wait list and what they said that they were issuing for the U visas for this fiscal year. So they said last year in September that they were going to be looking at cases placed for U visa status that were put on the wait list between mainly October 2013 and February 2014. So if we look at the wait list now, right, so we're dealing from about February to the summer of 2014, It might not be the case that they're going to be waiting for a really long time, because if you're on the wait list, then chances are they might be looking at your case fairly soon for the next fiscal year, and being able to give you issue a full 4-year visa. So I wouldn't go under the assumption that they're not necessarily going to look at it right away. Sorry, that's just me thinking out loud. So what do we do? All right, let me turn back to the poll. 70% of you would wait a minute to allow the client to gain some equities. And so I think that is something that happens. And Jess actually has a point that there might always be a chance that you find out about the conviction from an RFE, because depending on whether or not your client is forthcoming and telling you what happened after going onto the wait list. So I think that there is a likelihood that maybe once the prints are run again to be issuing a full 4-year visa, that you might get an RFE on this as well. I think that most people will wait to file, to let them know, and to be allowed to gain some equities. But again, if it's, let's consider it. Remember to do the analysis before then. Would shoplifting be a CIMT, right? Which is subject to the petty offense exception. And so it's important at the outset to do the analysis to see whether or not, if it rises to the level of a crime of moral turpitude, if there's an exception that might be available, and that your client still warrants a favorable exercise of discretion. Let's move on. And I think Gail's having some technical difficulties, so Gail, please weigh in if you have any thoughts.
Yeah, how am I sounding now? This calling in thing is not working for me, so if this is sounding okay, I'd rather do this because I'm not having luck calling it. Okay.
Okay. So RFE processing times. Ideally, you should be getting something within the period of around 60 days. Are people seeing that, or what are people seeing as the, if you're getting any kind of response after filing an RFE? What is the time frame that you're seeing? Okay, Kareem says they're not seeing 60 days. Sometimes it's 2 months, sometimes it's longer. 60 to 90-day period. If you think that you have gone beyond 90 days without something, definitely let me know, because I think that we can kind of consider we can kind of check in with USCIS to see whether or not there's a problem with the case. So if you're seeing something beyond 90 days, do reach out. First of all, make sure that you reach out to the hotline first and say, hey, we've been waiting for a while. Is everything okay? And if you don't hear anything back from the hotline or anything useful, then you can circle back with us and we can see what we can do from there. Ordinarily, requesting supervisory review through the hotline is something that has been done before. If you think that there's something that is particularly, 1, egregious, or 2, kind of incorrect. And from there, I think that, again, reaching out, you can request supervisory review through the hotline, but I would not expect that you are going to get the RFE rescinded through the hotline. And so I think that it is something that we need to make sure that we are responding on time. And even if with the information that we have, you want to make sure that you respond. And in your response, you can request supervisory review, or follow up with the hotline after you submit your RFE response to make sure that a supervisor looks at it. We've had some issues out of the Nebraska Service Center, which I hope has been resolved, that the RFE itself and then the envelope that was on it had different addresses. And so they said that if you notice inconsistency between the RFE response envelope and the RFE notice itself, that the address that is on the notice is the one that controls. But they said that they were going to be fixing that issue. I don't think we have seen that recently. Another thing that people have done with the envelopes is to attach the envelope to maybe the front of the submission so that it can be routed faster if it's going to the Nebraska Service Center. And I know that that is kind of something that, as a practice tip, something they recommend that could be helpful.
But the
Anything to add,
system for, yeah, so Cecilia, the system for them getting our help with bad RFEs is the same once they send their physical reply to either Nebraska or Vermont, correct? Is that what we suggest you do is contact us, and we have a format we like you to fill out where you basically succinctly explain what's going on, you attach the relevant documents that you already sent, and then you send it to the hotline, and it's the same hotline for both 8 parts of the agency. And you CC us, and then we monitor what goes on and take it up to the decision makers if it doesn't get resolved at the supervisory level.
Right, but it's important that you try to resolve it through the hotline first. But
Right.
kind of keeping us in the loop is the next step, making sure that we are able to follow up with it.
And to reiterate, I think the point you made, the general point to tease out, is you should always formally reply in writing. That you don't want to give them the out of denying your case for failing to reply in writing. So although in the past, when there were fewer casers and fewer practitioners and fewer adjudicators, the hotline would sometimes resolve things without you having to file. Now you've got to file before a deadline.
Right.
Okay, we're ready to move on?
All right.
Okay, I think I'm doing this one, and then it's back to you. So the reason I'm doing this one is that I feel very strongly that there are many ways that you can avoid some of the problems that you may be getting back. This is just because we've been doing technical assistance with you all I've been doing it for over 20 years, and I think Cecilia's now been doing it for many years. And we see often that part of the problem, not all of the problem, but part of the problem may sometimes be that the way you've submitted things doesn't make it as easy as possible for someone an adjudicator to figure out what's going on. So the vision I like to have you pull up in your head is you're walking into it literally is a little cubicle. You have a huge pile of folders that you have to open. You're just getting your coffee. You open a folder, and one of them literally summarizes in bullet points how your client meets the requirements. The other one you open up is just a whole pile of documents. Which one are you going to do first? So it's kind of like the normal person approach to this. So the more that you set this up with bullet points, and I like to call it a roadmap cover letter, and then you must index your documents if you have anything that's at all complicated. And we even recommend you do little summaries within the index of how each document shows that eligibility requirement that you're trying to meet. And we have some samples that are in the materials that you can download if you haven't already, that are designed for U visas. And what I learned this when I was doing asylum before I started doing any of this, that actually, in addition to doing the index of the roadmap, literally take a highlighter to the parts of the declarations and the other supporting documents you want them to read. What parts do you want them to read? And literally highlight them. So that if you're the adjudicator, you look at the bullet point checklist, you open up the documents, you look at the highlights, and you say, check, 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 check. Yes, this one's done. Okay, back to you, Cecilia. Unless, is there anything come up in the chat that we should respond to?
Nope. So some general tips. Look at the front and the back. Sometimes they have things at the very, very top of the back, and so make sure that you are looking at all pieces. Respond on time. And if you don't have what it is that they're asking for, then I think you need to explain why you don't have it and what you're trying to do to get it, or why it might not be available, and why what you are supplying and what you have supplied is credible and is sufficient to answer their concerns. And so I think sometimes it comes into question, sometimes with biometrics that you don't have them in time, or some kind of result of a criminal matter is not resolved by the time that your RFE response is due. And I think in that case, and I think they're especially flexible with the biometrics, is to say, listen, we are working on it. We're going to get it to you as soon as we can. And when you have it, then you can also make a copy of the front and back of RFE and follow up with them once you have it, and make sure through the hotline that you get it to them as well. They did mention recently that people have been trying to respond to RFEs via the hotline. That is not okay, that you should always respond to the RFE in paper with the RFE on top, because that really helps reroute it and make sure that it's there, and it will not be accepted as a response if it doesn't have a copy of the RFE on it. So make sure that you put that on there. And if for some reason that you're not going to have what they need in time and you think that you might be able to get it soon, to let them know and to follow up as soon as you're able to get it. Any other tips on this, Gail?
No, just basically what we said before. Even if you think you fixed it through the hotline, always respond in writing. Just because in our experience, ironically, it's easier for us to intervene and fix a problem that's based on substance than failure to follow the proper procedure.
Mm-hmm. Okay, next slide, please.
There you go.
Some more tips. This actually happened from maybe a few years ago, where they suggest being civil, to focus on what is wrong in the facts or legally. So saying something like, we understand that, the RFE might demonstrate an incomplete understanding of the context of domestic violence in the following ways, is more likely to be received better rather than like, you absolutely know nothing about domestic violence. So I think being civil in your response and focusing on the facts that are wrong or the legal analysis that are wrong rather than what the heck are you all doing, is going to be better.
Cecilia, I think this is even more important now that we have all these new people at the Nebraska Service Center. And our view, which you may know from if you're on our listservs, is that they've probably not been adequately trained on domestic violence and sexual assault and other victim issues. And many of them come from parts of CIS that really focus on fraud, especially marriage fraud. So we have experienced this many times when new people are added to Vermont. So again, this is where you may not understand this context, but here's the information. And view it as an education of the adjudicator and their supervisors at Nebraska. You're basically helping educate them on things that they may not know well.
Right, and again, like, we can help with training issues. If we notice something that in your RFE that you send us that is very far out of left field in terms of an analysis of the dynamics of domestic violence, or why people might be saying, why aren't you submitting your tax returns or asking for something specifically, then we can get involved and say, hey, like, we noticed in this RFE, we noticed in this NOID that they're using an incorrect standard, so we can kind of raise that as well if there's some kind of problem in the way that these issues are being viewed by the adjudicators.
Yeah, frequently, and we're actually coming to this, is we have to intervene on them applying the improper evidentiary standard.
Mm-hmm. And why don't we go to the next slide and you can explain more about that, Gail.
Okay, so as we hope all of you know, and we're going to kind of beat this a bit because it's really important, Congress did create a special evidentiary standard for U visas and VAWA, and I think D visas. That's the Any Credible Evidence Standard, and Cecilia's going to explain more of the background on that. But that doesn't mean that you can just send them anything, because the way they look at it is that what's credible is the best evidence that you can get. And if you can't get the kind of evidence they're used to, why? How did you try to get it? Why couldn't you get it? And then a short explanation of why what you're submitting instead is credible. And we'll get into this a little more now with the evidentiary standards of review. So, as you may know, there are generally there's a difference between the burden of proof and the standards for the evidence that you submit to meet that burden of proof. And I think this is a distinction that we have often seen practitioners mistake, kind of combining the two. So the burden is, how much does the adjudicator have to believe that what you're submitting shows what you're trying to submit, as opposed to what are you submitting to meet that burden. So the preponderance of the evidence is more than 50%. Clear and convincing, I don't think there's a percentage, but it's much higher. And then you're all familiar from the criminal context, the beyond reasonable doubt. Preponderance of the evidence is the burden that applies to VAWA and U's and T's. But the any credible evidence standard goes to the forms of evidence. So the best evidence, for those of you who've ever done any other kind of immigration case, you know that the best evidence is what they call primary evidence, and they actually define this in the regulations. And the way I summarize primary evidence is that it's basically...
yeah, you're breaking up a lot. It's kind of hard to hear you.
I don't know what to do about that. I'm holding it right up to my mouth. And calling in didn't work. So am I still breaking up?
A little bit. It was better for just a...
All right. Well, let me take this thing off. Is that better? I'm just doing it straight into my computer now. Is that better? Okay. So I'm just going to do it without my microphone and talk to the computer. So typical primary evidence is systems. I call it systems evidence. That's how I summarize it. So typically for U visas or VAWAs, it would be police reports, or if you're doing a VAWA, it would be hospital reports. It'd be the kind of things that come from sources that are government sources or court sources or other sources that CIS would not necessarily look behind because they are, or they shouldn't look behind because they are experts, allegedly, in producing the kind of evidence that they're submitting. Secondary evidence can be other sources, and that's where the typical declaration standard may come in, or in some other forms of relief, it can be other ways to show where you were born if you can't get the kind of primary evidence that you would show. Much of primary or secondary evidence, however, may not be available to victims of domestic and sexual violence for a variety of reasons that Cecilia will get into. And that's why Congress created the special any credible evidence standard for these forms of relief. So going back to that best evidence, you would want to explain why you can't get the systems evidence. It can be like one sentence. She didn't access systems because she was afraid or whatever. But here is the other evidence, and here's why it's credible. Now, I think it's turning to you, Cecilia, on the standard, how that applies to the standard.
Okay, so here, for VAWAs and for U's, and for VAWA especially, this is where they kind of get into it. They noticed that recognize specifically that abusers might control documentation. And so how getting primary evidence or secondary evidence is not necessarily going to be something that's possible in cases where there's domestic violence. And so if we can go to the next slide, I'm going to share with you my very favorite memo from, I guess this is pre-INA, so this is legacy INS, and this is talking about what is considered to be credible evidence. This memo also has a discussion of extreme hardship in VAWA cases, but seeing as that's not applicable anymore in that context, the discussion regarding credible evidence is extremely useful. So it says that applications for VAWA might be denied on evidentiary grounds if the evidence is not credible or otherwise fails to establish eligibility. But it doesn't require that a person demonstrate the unavailability of primary or secondary evidence. And so it also says that a self-petition may not be denied for failure to submit a particular form of evidence. And so it's within the service's discretion to say what that means, what evidence is credible, and what weight to give that evidence. And so that is why the check for credibility and the checking for inconsistencies within the documentation that you are submitting is crucial. And so it's making sure that the supplement B doesn't contradict with the police report, doesn't contradict with any kind of other documentation that you're submitting. And if there are inconsistencies, determining whether or not they are material. And again, this is also true if you're filing a VAWA petition, for example, and there's an I-130 that was submitted previously. Checking in with what was said in prior applications, whether or not maybe a grounded inadmissibility has been disclosed or not been disclosed. And so you want to address all of these issues up front to make sure that you are addressing any issues about credibility. And so you want to say, listen, we noticed that this thing might be different from the other. Here is the reason. Here is the explanation for that. And to deal with it up front if you're able is going to be really important. But I invite you all to read that discussion about credible evidence in the Virtue Memo. I think within your materials, and if not, then I'll make sure that that you get it. The next slide, please. Again, these are very practical tips from the Vermont Service Center that every applicant has his or her own G28. So including the principals of each derivative has their own G28. That page numbers are helpful, in particular for something like a statement, personal statement, that is two-hole punched on top, not to submit double-sided documents because they are kind of reorganized and shuffled and they're kind of put into their own folders, and so kind of flipping the way that the documents are, or having everything single-sided is much easier. And again, your tabs and your section dividers, why they are useful and they are pretty, are put at the bottom of the application package. That's not to say that they're not necessarily useful, but that they are kind of put towards the end when they are putting the documents in their own files. The next slide, please. So again, this is an order that they say is useful. The G28 on top, the application or the petition, then the supporting documentation. And then if you're doing a U visa, that you do the 918, and then the sub B, and then the third form is having the affidavit or declaration in terms of the order that they find helpful with the documentation.
You want the next slide, Cecilia?
Yes, please. I was actually just kind of thinking about where, and that's kind of the cover letter and the index would go. And they also have recommended, I think I would still kind of, and they would also recommended that each individual applicant, whether or not you're maybe submitting a U visa with 4 derivatives, that everyone have their own index. Because sometimes the applications can get separated, and so having an index for each of the applicants is useful in terms of organization. The next slide. Okay. So boilerplate RFEs are something that shouldn't be happening. And so they should discuss. And yes, but they have said that it is against their policy to submit boilerplate RFEs. And so what that means, a boilerplate RFE, is that they request information without any kind of discussion or analysis of how what was submitted is insufficient or inconsistent. If they just say, you need to provide more information on good faith marriage, and here's all the things that you could potentially use to prove good faith marriage. They should at least say why what you're submitted it was problematic or didn't make sense or was not enough. And so if you get a RFE that looks like this, that doesn't say that how what you submitted was problematic, then follow up with a hotline, CC us, and we will let people know that this is happening. Next slide, please. Again, we kind of talked about this in the kind of first little poll that we did. And if you Make sure that you have that cover letter, that roadmap, and that index so that you know when the adjudicator knows what it is that you are submitting. And I would literally highlight where you supplied it if they're asking for a document that they already asked for. And again, don't go overboard. Try to find something new if you already gave it to them. And if this is a situation that you're running across, you can just let us know. We can raise it with the heads of the VAWA unit if you're running into this issue. So this is where it gets a little trickier, right? Where you think that the RFE is wrong in the facts and wrong in the law, or asks for things that should not be relevant to the eligibility, or somehow mischaracterizes evidence that you supplied, or sometimes has details from a case that is not yours. It's been known to happen. And so where you see something where the RFE is wrong, it mischaracterizes or it's wrong in the facts, respond to it, and then ask for supervisory review through the hotline. And then let us know about it. And let us know if you get any pushback, or if it's particularly egregious in terms of the way on the law, then we definitely want to know, and we could raise that up as well.
Okay, so now I think I'm taking over, and Cecilia, if you're typing, maybe you can, I was trying to figure out how to mute typing while I was talking. We haven't quite figured that out yet, but I think I'm going to take this for a little while. So the most common VAWA requests for evidence we see are on, well, there's several of them. We're starting with the ones on declarations. This is actually often where I will give you guys some pushback, because what we see, again, when you're thinking about preparing your declarations, is remember that these adjudicators are never going to, at least unless the law changes or the regulations change, are never going to actually meet your client or interview your client. So everything, especially credibility and the details that show both credibility and eligibility, are going to have to be done in writing. So the detail that they mean is factual, idiosyncratic, factual detail. Often what I see is, and it's partly because it's traumatic for your clients to go through the details of what they experienced, but frankly, without that detail, it sounds like they could have just gone to a website and seen what are the different ways that people can show that they are victims of whatever the crime is, sexual assault or domestic violence, and writing that down. And that's what's in the back of their head, because they are charged with identifying fraud. And if it looks to them like someone basically got on a website and just wrote down what they found there, they're not going to find that credible. So go back through your client's declarations. It'll take, and this is again, we're partnering with domestic violence or sexual assault counselors, can be very helpful. They can do the in-depth interviews with their client, what I call the tip of the iceberg exploration, where you get a little tidbit from the client, and then at the next interview you explore that in more detail or ask them to go home and think about it and come back and explain it some more. That's the level of detail that you need to provide for these cases. One way to think about it is if there are any adjectives or adverbs or opinions in there, those probably need to be broken down to facts that lead to those adjectives or adverbs or opinions. At least it's a good place to start. The second one, they are applying the wrong standard. And this, I think, comes from adjudicators, new adjudicators, who have not been well trained on the any credible evidence standard and how it applies to supporting declarations. If you have seen an RFE that says we're dismissing the supporting declaration because the person was not a witness to the event, or was not there firsthand, that's the improper standard for U visas and VAWA. That's a standard derived from other forms of immigration application. And many of these issues, I cannot tell you how many times we've gone through it with Vermont and CIS. So basically all we have to do is forward that to them and say, you agree this is wrong, can you please fix it? It looks like a training issue. So that kind of RFE where it looks like they're just applying the law wrong, like they don't get some fundamental aspect of the law or the evidentiary standard, let us know right away, because those we should take immediately to the heads. You'll still have to go through this, going through the motions, quote unquote, to comply with the formal reply requirements. But we should get the information on that adjudicator to the heads of the unit right away so they realize there's a training issue. Okay, so I think it's idiosyncratic. I'll have to fix that. Boring, idiosyncratic
Mhm.
details of events. And so the same
So
thing
Gail, we have
applies
a
to
question.
claims.
We have a question, Gail.
Oh, yeah, sure. Okay,
It
so the
says that
applicant has no
applicant.
one who has witnessed DV, but is in contact with family back home. Uh, so what do you think, Cecilia? Are affidavits from family members accepted even though they are not physical witnesses? And maybe those of
One
you
thing,
who are listening can respond
yeah, I
and with
mean, a
examples
lot of the
if you want.
times too, yeah, and I think this happens all the time where that a survivor might reach out to a friend or to a neighbor or someone who about what it is that they are experiencing. And the person, I think those supporting documents are useful because they can kind of say, this is something that they said, and when they were explaining to me what happened, that they were crying, that they were upset, they were distressed, like they were distressed. And so I think that even if there's no one who physically witnessed the abuse, that type of information about what the applicant relayed to them, about their effect when relaying that information and how they looked or how they sounded is credible evidence.
And Jennifer says she's
Exactly.
had family members abroad write statements about phone conversations. So I think it's helpful to back up here, talk about how we got to this standard, because this U visa came after the Violence Against Women Act self-petitions, and we did a lot of work with Congress and Citizenship and Immigration Services, working with the domestic violence field on educating them on why kind of normal evidence wouldn't be available to a survivor because of abuser control. Most abusers don't go say, "Oh, I need a witness to the abuse." They're very cagey about that. So that's why that memo that Cecilia cited is so helpful, and it talks about that, and it also now applies to U visas. And if they haven't been well trained, they're not going to understand it. But the second piece in general is that hearsay is okay in immigration, and particularly with the any credible evidence standard. Again, however, it's vital that they give the facts of why they believe it. So the facts may not be what they witnessed per se, but what in terms of the acts by the perpetrator. But as Cecilia said, they can be relaying the facts of what they have heard from the survivor and what they've seen about the survivor. And with counselors, rape crisis or domestic violence counselors or sexual assault counselors, they can also what I call kind of interpret for the adjudicator why those facts are forms of domestic violence or sexual assault, let's assume for now that you're dealing with adjudicators who have not been as well trained on what the experience, the context of domestic and sexual violence is as you are. And so that's where and that's again why we have always promoted a partnership model, and OVW promotes a partnership model for those of you who are lawyers to actually partner with a domestic or sexual violence counselor. Not only can they help with the actual evidence collection, but through doing that, they could write a corroborating declaration about how, she can't talk about what happened, but from what she said, this is what I believe happened, that kind of thing. And that's why we're here to help you with all of that if you have questions about that. And better to do this up front than waiting to get a request for evidence or a notice of intent to deny that raises these issues, because inevitably we see if you come back with new information or new approaches, they wonder if you're telling the truth and you're just doing it because they told you to do it. So the more you can do it up front, the better. And if you have a question about timing, if there's an issue with getting things filed for one reason or another, talk to us, let us know. We'll help you figure out, does it have to be perfect now, or should you go ahead and file something before it's perfect? So here's and this is I wrote up little guidelines for domestic violence advocates and advocates helping with U visas. So they're not templates, because we don't, again, you want to avoid that thing where it looks like this is frauds. And the other thing they've told us over the years is if everyone's sending in something that looks exactly the same thing, like it's a fill in the blank, we don't really give them much credence because it doesn't look idiosyncratic. They don't use the word idiosyncratic, but it doesn't look individualized and particularized to your client. So what the declaration does is explain, here's what you do in the first paragraph, here's what you do in the second one, mainly because, these folks may be a little afraid of what writing a declaration is about. And as you all know, it's really not that big a deal. And so the idea is to get them over that hump of fear and make it easy for them to do. Okay, so, yep, I think I kind of covered that. Is there something we should address in the chat, Cecilia, before we move on? Okay, I'm not hearing her, so maybe she's addressing it with you directly. Okay.
Sorry, I was muted.
So
yes, hold on.
okay.
And so I think that there are some things in the chat boxes that.
Okay, good. Just some apologies to the audience because when it's really hard to tell
Right.
what's going on when you're on a webinar as opposed to in person. So yeah, go for it, Cecilia.
No, but I think the thing is because they just echoed the point that that kind of the collaboration for that kind of emotional abuse and isolation. That's kind of ways to do it is kind of those supporting documentations like Jennifer had mentioned. And I don't know if there's necessarily, I think that evidence for someone who is a friend, is a neighbor, is a colleague, who is a victim advocate, to be able to provide that kind of information, I think is helpful. And I think within the context of domestic violence and the types of evidence that is going to be available, it's something I think that Vermont is used to seeing.
Okay, it looks like we're mostly getting confirmation that the folks out there have been having these kinds of issues. Let's move on to the next one. We're happy to come back to this later. The other big problem, the legal issue we're dealing with VAWAs, and we're still basically in knockdown, drag-out fights with CIS over this, is them finding that your clients are not in good faith marriages. And there are two things going on here, I think, is that this is their big fraud check for VAWAs, is good faith marriage. The bad thing is I think they're actually holding VAWAs to a higher standard than they do to regular family-based cases. And I think we supplied two amicus briefs we've written to the Administrative Appeals Office highlighting these ongoing systemic, what we think are legal inaccuracies in the way some adjudicators are handling the cases. And so far we have not succeeded in getting anything overturned, but if you want to take a look at those, they'll give you a sense of the kinds of problems that you may encounter, and you could kind of, I like to use the word, head it off at the pass. If you know that in your case you may have one of these problems, you can literally cut and paste some of the arguments if you need it, but contact us so we can help you figure out the best way to frame this so it isn't too lawyerly. And then also anticipate more evidence you may need to collect and be very specific about for good faith marriage. Again, this is where details are vital. So go through from the very beginning of the first encounter with the spouse in case of VAWA, and even if it was before the marriage, details, not just he met me here and we fell in love. We met, through online dating, and we exchanged 3 emails, and he showed me his picture, and I showed, boring detail. Cannot say this enough. That's what makes it credible and different from every other case that they're looking at.
Hey, Jeff, can I ask you a question? And this is something that just came up in the chat box. Is that what do you do to combat language in the RFE or otherwise, or just like, sometimes things don't work out, or sometimes things go bad in marriages. It doesn't necessarily mean that it's abusive. And that's something that I think sometimes is a really common issue.
Right. Well, so on the one hand, it's true that VAWA in particular is about, power and control, as we like to say. It's about violence against women and men occasionally, but the dynamics of that, it's not about bad marriages. So you do need to draw that distinction. On the other hand, often what we'll see is that, again, it's a tip of the iceberg, that something that looks like it might be a bad marriage indicates that there are other forms of power and control going on. And you may need to work with a counselor to get to that level, or you may have submitted it, and this is the second big issue that we're seeing, particularly, I'd say, with the NBC folks and some of the new people Vermont brought in a couple of years ago, is they don't understand domestic violence. They don't understand all the ways that it can manifest itself and how you can show it. And again, so these are cases, if you're seeing that, that's where before you even reply, as soon as you get it, send it to us and say, can we do a little reality check here? And we'll probably ask to review your declarations to see if they're right. But if they're wrong, then again, this is the kind of thing you'll still have to reply, but you may only have to do a very minimalist response that says, excuse us, seems like you're not understanding DV. Please read the following documents more clearly. And at the same time, we'll take them up to the heads of the unit and headquarters and say, this looks like this person needs a little more training. Can you pull the file and please take care of it yourself?
Right. And I
Does
think
that
it's also sometimes an issue where, for example, a client might be more focused on like infidelity than,
yes.
social isolation or not necessarily having an economic resources. And so that's why I think having a tool like the Immigration Power and Control Wheel is really useful as a starting point in evaluating the types of conduct and the types of things that would establish that pattern of control and of maintaining power. And so while some focus might be on one thing or another, so then as you kind of look at something in the totality, is another way I think is a useful way to look at it.
Right. Yeah, and again, if you're dealing with non-physical violence, this is again where having a declaration from a counselor is very helpful because they can provide, she told me this, this, and this, and this happened, and this is what we call isolation and economic control in the domestic violence area. And those are very typical of abusers, and the things that this abuser did were very typical of abusers. So again, that helps educate them about the context, and it also makes it much easier for us to do the interventions. And the second piece that Cecilia's alluding to is you can edit your client's declarations. You can edit and organize
Mm-hmm.
them. It does need to sound like it does need to come from the client. It needs to be in the client's words, but you can edit out all that stuff about I'm really mad I didn't get paid, I'm really mad, about things that aren't forms of power and control, and just focus on the power and control issues for Baba.
Right, and
Okay,
that's why
so
having someone who is an advocate, having someone who has that experience who can say, I have been working in the field of domestic violence for 15 years, this is my experience, and this is how X, Y, and Z, all fits within the realm of domestic violence. And I think having that as supporting documentation is also very helpful in those cases.
looks like a lot of this is happening with you guys. That's good. Some of you are asking very long chat questions, and what we'll ask you to do is contact us afterwards, and we'll go through the cases with you, because that level of detail is what we're basically paid by OVW to do
Right,
with you.
and to
So.
Jennifer's, yeah, exactly, and to Jennifer's point, and so that it's, those insults, the name calling, the put downs, the threats to call immigration, kind of beyond other things. I think it's all really good that you're highlighting all these issues.
Yes. So moving on to the U visas. The big problem that we're seeing with U visas, with RFEs, the biggest problem is the waivers for inadmissibility. And for those of you who've been doing this a while, there are two things to think about with your waivers of inadmissibility. What are the grounds of inadmissibility I need waived? Have I adequately identified them for the government and asked to have them waived? That's a legal issue, is whether your client has triggered a ground of inadmissibility. The second part of it is that Vermont and Nebraska can use their discretion in weighing the pros and cons that you've submitted to show whether it's in the public interest to overcome those grounds of inadmissibility. So what we still see, I don't think we've seen anybody getting denied for EWEs or unlawful presence or anything very simple like that yet. Have you, Cecilia? I mean, historically, that's not been the problems we've seen with these. It's mostly
No, I haven't.
crimes, right? Okay. Yeah, the biggest issue is going to be with crimes. We do see them coming back and noticing grounds that you haven't identified. So the second piece is really important. You've got to literally cite every ground and every subsection of every ground that you want waived. So for instance, if your client has both a false claim to U.S. citizenship and an immigration fraud waiver, you need to cite the subsections of 212A6C, not just 212A6C, because we've seen people go abroad thinking everything's waived, and then the consulate says, oh, wait a minute, you got immigration fraud waived, but you didn't get the false USC waived, and so now you're having to deal with that while your client is stuck abroad. We do ask you, is in general, to emphasize the D14 waiver, which at least now the form allows you to check D14. It didn't used to. Um, and I think for really sticky questions, it's I like to have you think about how would you explain to neighbors who aren't lawyers at, a barbecue why they should want this person living in your neighborhood. And the reason you can work backwards from there and be more lawyery and kind of legal argumentative, but the reality is that this standard is different than many of the other standards you see in immigration law. Public interest may include, but it isn't necessarily the same as like you keeping the family together or general humanitarian concerns. Those tend to focus more on the victim and their family. Public means everybody else. So think about that. And that's why you'll often see, I think, serious problems getting, for instance, juveniles with multiple DUIs and no light at the end of the tunnel for them changing their behavior. It's going to be very hard to get those kinds of cases waived. Okay, I'm not going to read the chat, so you intercept if you need anything from the chat. Okay.
Yeah, it's so the other said the question is regarding smuggling, whether or not you're addressing smuggling for a parent who brings in a minor child easily.
Right. So I would suggest that in general, this is again very different if any of you do any other kinds of immigration cases. I think this is very different than what you may have learned as a regular lawyer because, and I think this is still true. I'm sorry, I'm like creating noise. And we may change this approach in the coming years, but we have always found that basically the term I use, it's better to fess up and ask for forgiveness than it is to hide the ball or even to give them the inkling that you may be hiding the ball on an issue. So even if you think something doesn't actually trigger a ground of inadmissibility, like crimes of moral turpitude, there are actually exceptions that may apply, right? As opposed to waivers. So I would still say you may think this is a crime of moral turpitude based on the facts that we presented, but here is why it's not. However, if you decide it still is, here are our public interest waiver arguments. And that way you're heading off at the pass, them coming back and thinking you're hiding the ball. And regardless of whether they understand the law of crimes of moral turpitude, and as a footnote, I would say do not expect adjudicators to understand any of the legal background on grounds of inadmissibility. You will at least hopefully by being upfront and giving them all the information they need to make a positive discretionary determination, you won't get an RFE or a kickback. Let's see.
And what's your sense, Gail, if you don't know, for example, if there's an expedited removal, you don't know what happened at the border, and you're not going to know until after the Sub D might expire. So you have to file. But what if you do if you don't have all the information that you need regarding, potential issues of immigration history?
I think that's, you definitely want to put that up front, and you could say, we did the FOIAs, we haven't gotten them back yet. We assume you can check for this, and if she did, here's our arguments. So for smuggling would be the perfect example, right? You may think she smuggled, but the exception apply, or we can't tell if she smuggled based on what she told us, but if she did, here's why it's in the public interest to waive it anyway. And that way you've covered the bases so that they shouldn't have to come back and ask for anything more, except maybe more documentation of why they meet the public interest.
Right, and I think it's also the case that, chances are, that you want to get it in time before your supplement fee expires, but they're not going to be looking at the case for a long time. And so I think you can kind of say we'll supplement the file once we have the information, but for expedited removal, they should be able to check and they would RFE you. But you can kind of say what you know, how much you know, and that it's what information you have. Then you can kind of say, all right, we did a FOIA and we're waiting for the results of that, and we will, amend the application accordingly as we need to, depending on what that result is.
And we'll be coming back to this later. There's virtually nothing that's going to prevent them from entertaining your application, except for being a Nazi, right? So old removal orders, old failures to voluntarily depart. We have legal arguments for how you can overcome all of those for U visas. So there's really no downside to admitting to facts that may cause problems as long as you have very good equity arguments. And again, really the big issues we're seeing are crimes and like massive and apparently unending immigration violations. Otherwise, we're still not seeing waivers being difficult to get for everything else.
Right. And at the same time, I think that it's also kind of the flip side of that. Like if we just don't have enough information saying, you know what, there potentially might be X issue, we don't know if it rises to the level of a ground admissibility because we do not have all the information. And once we do, we will, let you know. So
Yeah,
not
so I think
necessarily
that
submit facts if you're not certain of.
right. And that goes to what Dahlia is saying, I think, is that they may ask for, and you'll often see this with BAWAs, they'll ask for police reports for good moral character and you can't get them. Again, head them off at the pass. If you anticipate they'll want something, say, we can't get this, or we're trying to get this, but we haven't gotten it yet, and we have to file. Here's what we do have. If you think that's enough, can you go ahead and grant? If you don't, please send us an RFE or give us more time. And often, I think, at least in the past, they've kind of applied a good faith attempt by the attorney notion to that. So if you looks like you're giving them everything and being really honest with them, that tends to help you in terms of whether they're going to grant your client. And one thing you should know is they pay attention to who you are. They keep track of the attorneys, so that if you want to build a reputation for honesty with them for your clients down the line, if they start questioning whether you're honest, then you're going to have problems with all of your cases. Okay, massive immigration violations. Yeah, I would say um, anyone who's subject to reinstatement of removal, for instance, I would not call that necessarily a massive immigration violation since it happens all the time. But if you've gotten to that point where you're triggering 241A5, and if you don't know what it is, you got to print it out and keep it on your desk, then you should contact us to talk about what your argument should be on that. Okay, review of discretion. As you know, it's only in the regulations, it's not in the statute, that you basically get zero review of their denial of a waiver based on discretion. But the AAO can review legal issues, and they have asserted that. They also have asserted that since the regulations don't say they don't have discretion in the adjustment context, that they will review it, and we've seen them review in reverse. So we really ultimately want to get the regs changed, and we may think about other ways to get them to change it so the AAA can review discretion of your waivers. But meanwhile, if you've really gotten to the point where you've done motions to Vermont with new evidence and new arguments and they still won't grant, you're going to have to go to the AAO. And we've developed some briefs arguing that their complete failure to implement the special D14 standard is a legal issue that the AAO can review. And it is. They can't just say we're not going to implement a law that Congress passed. And if you've seen their RFEs on waivers, they basically say, well, there's no case law on this, which frankly is because they won't let us appeal their cases. So we're just going to use D3. And to us, that's a massive legal violation that they are not applying the standard. So if you need to go to the AAO, we would suggest you make the arguments that they're violating the law for failure to do D14. And if we can eventually get the AAO to open the door with that, then perhaps we can get them to review something internal on that, although I'm not sure about that. But at least they can go back to Vermont and say you have to use other factors and come up with some factors besides D3. Okay, so I'll let you jump in, Cecilia, if you want to tell me anything that's in the chat so we can move on through this. This is a big one, kind of an advanced issue, but it's happening a lot, where you are, as a routine, they're sending RFEs asking for police reports and things that, for those of you who are familiar with the criminal immigration context, would violate the law, basically because of due process issues. They're based on hearsay. You don't have the ability to challenge what's in a police report, that kind of thing. And so the law says that they can't use things that are outside what's called the record of conviction to decide whether your client is inadmissible. They argue that that doesn't mean they can't use it for discretion. We argue back saying the same reasons it violates due process to use it to decide if someone's inadmissible, it violates due process for you to be relying on that to determine discretion. We haven't won that one yet, but we've got those, we're working on those arguments and we can share them with you. But that goes back to
Right.
that hypothesis
And
you did.
and that also kind of goes to Marty's point about what we're seeing recently about juvenile offenses, which is similar but also kind of different behind a way, because juvenile system, I think, is civil and technically. And so I think, it's something that we are noticing as not only a trend in police reports, but also looking at the juvenile records as well. Gail, I think that this webinar is only scheduled to go to 3:30.
So we need to move on. But I do think, Marty, that's a good one we can take to the AAO. I think that's a legal violation, so we can move on with that. There you go. There it is. So again, this goes back to that hypo. You may decide you're going to supply it anyway, and that's fine because it's easier and it's helpful. And what we would ask is that you then make the arguments that it's unlawful for them to be asking for it. Quick thing on crimes categories, I really plead with you to frame things that aren't clearly in a category, not as similar, but as categories. And if you have those issues, we can have that conversation offline. We can get back to the kind of more fundamental stuff. This is it. Sup B is important. If you're having trouble getting your Sup B organized in a way that's helpful, let us know. And we've got examples of how to organize your arguments about why a crime fits a category that we can share with you that others have used successfully. So the other thing we're seeing with certifications, it's actually just a certification says not helpful. I think there's still ways you can use certifications that at least sign the right checkbox and then say they're not helpful. So again, don't assume that you shouldn't file. Contact us and we can figure out ways to prepare and frame your arguments despite that finding. And again, this is where we think working with your partners in the DVSA community is very helpful. I think they're often your survivor clients. If someone worked with them and with law enforcement, you could negotiate a solution that made your survivor feel safe while getting law enforcement what it needed to sign a certification. And I have to keep saying this to lawyers. You guys need to remember this, that Congress created this for two reasons. It's not just about humanitarian relief. It's about helping law enforcement reach communities it couldn't reach. So every time you're thinking about this with your clients, think about, is what my client's doing helping them hold perpetrators accountable or creating a barrier to it? And if it's creating a barrier, is there any way that we can overcome that? Okay, I think it's back to you, Cecilia, on this one.
Okay. So here, so you have a case that's on the wait list and you get an RFE. Even though it's on the wait list, you have deferred action. What is going on? And there's two circumstances in which this would happen. One is sometimes they have these kind of random quality control checks regarding whether or not the information that how they evaluated the case the first time is still the way that they should look at it. Or there is new evidence that comes to their attention, like our friend who was convicted of shoplifting. And so that might kind of be issued an RFE. And so what that means is that the case is taken off of the wait list until the issue of the RFE is reviewed. But that still means that if they have deferred action status, the EAD remains valid unless the case is ultimately denied. But basically what that means is that you would kind of lose your place in line until the case has been adjudicated. And if it's adjudicated, the RFE is decided in your favor, then you get back in line in the same place you were. And
they fixed that based on your intervention, I think, Cecilia, right? Because they weren't doing that, so that's at least something.
It was unclear because they said that you're off the wait list. I think that the question was, what does that mean for your EAD? And what they said is that the deferred action work permit remains valid unless the case is ultimately denied, unless what you submit in response to the RFE is not enough and they ultimately deny the case, and then that is when the EAD based on C14 would no longer be valid.
Okay, so just an update from the gals running this. They said we can keep this until 4 o'clock East Coast time. I know some of you are going to have to get off in 15 minutes, so my plan, because I think I'm doing most of the rest of this, is just because it's all very advanced. So I think I'll just highlight it for you as we go through and make sure that so that the captioner can also get all of that. And then we'll stay on for the last half hour, come back to all these questions that you have, because we would like to be able to get to them. I don't know, Patricia, will it all be recorded through the full 2 hours? As we move along, you
We
can
can
let us know.
record the entire thing if you'd like.
Excellent. Okay, so those of you who have to get off at 3:30, you're going to send out the recording afterwards, right? So that folks can listen to what they missed. Okay, so couple practice pointers on the emerging issues that we're seeing. Ongoing helpfulness. Again, you may be seeing this with new adjudicators. The regulations are clear that you don't actually have to get a new certification from law enforcement. Their interpretation of the statute is backwards, and when we pointed that out in our response to their draft regulations, that's where they came up with this alternative to getting a new certification. So my basic practice pointers: don't kill yourself getting a new certification. If you can't figure out how to prove ongoing helpfulness, let us know. I think basically you just want to keep a record from the beginning of every contact you've had with law enforcement, or they've called you, and whether the case has been closed and all that kind of thing. Okay, continuous presence. I think there may have been some very overly limited approaches some of the adjudicators have been using to show you, asking you for evidence on continuous precedence. Share that with us in the RFEs and NOIDs you're getting. We've also seen them agree that you can reaccrue continuous precedence once you've broken it. They haven't actually said that, but they've granted after we made the arguments to them. So if you have an issue like that, let us know. Reinstatement. Again, reinstatement is basically you were removed, and you were here for a while, you were removed, and then you came back in unlawfully. And they've agreed that for both VAWAs and U visas, you can overcome it. With U visas, it's easy. With VAWAs, it's less obvious. I'll move on to the VAWA here. Oops, nope, I guess I don't have it in here. So the VAWA is that that you get the predicate for both of them. You get the predicate inadmissibility ground of 212A9C, which is the accrual of unlawful presence. You leave it and come back in unlawfully, or try to get back in unlawfully. You get that waived. That overcomes reinstatement, because that's essentially the essence of reinstatement. It's the same. It's the same elements. The waiver for doing that for VAWA is more complicated than for the U, which is just the D14 waiver. And we included in the materials the AAO agreement that if you get a 212A9C waiver for U visa, you've overcome reinstatement. In absentia, just for those of you who aren't familiar, in absentia orders are actually slightly different than regular final orders, and technically, to fix them in proceedings, you have to get what's called, do a motion to rescind. We are now proffering an argument that was suggested to us that if you could try getting it fixed at the waiver stage by a lot of spelling errors in here. I'm sorry about that. Keeping you on your toes. But getting the 212A6B section of inadmissibility waived, which I had actually was completely unfamiliar with, never having to ask for it before. It's a failure to attend removal proceeding, and we included that in the document that says INA cites for a cease to presentation. I also included the actual language from the in absentia part of the statute, so you can see where the legal argument comes from. So this is an example of us working with all of you to come up with new, novel legal arguments, and we're just at the point of now making these arguments. So let us know right away if you have an in absentia order case that in a U visa that you think might be problematic. Failure to voluntarily depart. Similarly, they recently agreed with an AAO decision that says U visas cannot adjust status if they had failed to comply with a voluntary departure order, and the only exception they noted was lack of voluntariness. But the reality is there are a whole lot of other exceptions to failure to voluntarily depart that are established in the regular immigration case law that weren't acknowledged in that memo. So again, if you get a pushback on that, or you identify that now, that your client had a failure to voluntarily depart, let's figure out how to set it up now so you don't have to deal with it at the adjustment stage. It doesn't preclude getting the U visa approved. It may create barriers for them perfecting their status at adjustment. And here's some of the arguments. These are some based on statute, some based on regulation, some based on case law, and I'm not going to go into detail since we're running out of time, and we can come back to it later. Parole. Cecilia, tell them a little bit about the parole project that we have been working on.
Right. So I think that the parole policy, the parole right now is what we suggest, and we have our materials on our website, and I think that they were shared with you as well. We did an advisory with Clinic on how to frame requests for parole using the 212D5 statutory framework. And so I think that is where how we are going to have to frame the parole request for those who who are on the wait list, who have family members abroad. We have that advisory on our website, and we encourage you to take a look at it. We have sample cover letters that we have suggested about how the statutory framework at 212D5 fits into the purpose for the U visa, in particular because the U visa program itself provides a significant public benefit in terms of encouraging cooperation in the investigation and prosecution of crimes and making communities safer. And also if there are kind of urgent humanitarian interests in the cases that we have seen that have been approved based on 212D5, I think that they have had some kind of framework within the humanitarian urgency issue, that there is some kind of emergency, that family communication is necessary. So we encourage you to look at it, to try it out. And if you do try it out, to let us know, and so we can make sure that we are keeping track of how these applications are going.
And where you file it is crucial, right, Cecilia? Because Vermont's a black hole. They won't do it, and they'll take your money.
Follow. Don't do it. So what happens is you would follow the instructions for the application, and it's filed with the lockbox, and it's routed to Washington, D.C. So yeah, I think a year ago or so, some people were trying to get these applications filed with Vermont Service Center, but it will go into a black hole and never come out. So be sure that you follow the instructions on the 131 where to file an application for humanitarian parole.
And we would like to know that you're doing this,
Yes,
because at this point
100%.
we don't think, right? We think it's very unlikely CIS is going to issue the memo that they were going to issue now, right? So we're going to have to do this under the radar, I think, at this point, getting the agency to do.
Or according to the statutory authority, the statutory authority, we're going to have to do it under the statute.
Right. I think we managed to get through this. Yeah.
Excellent.
All right, so I'm going to put up the resources slide, and we can come back. And sorry, we threw all that stuff at you at the end. But the next round, we're going to do 2 hours because that gives us plenty of time to go into it and do Q&A with you. But we are here now for the last half hour. Maybe those of you who have to get off, can't stay on, you could submit any chat questions you have now. We'll get to those first. Mm-hmm. Did you do all the chats already?
Yep.
Okay. Well, I'm going to go back to Marty's thing about juvenile convictions. So I think if they are saying that they are denying a U application, it's probably a derivative U application, right? Because of juvenile convictions, but they don't cite any ground of inadmissibility. I think that's a legal argument we can take to the AAO because they don't have discretion. The discretion is with waivers. It's not with, they're basically, I think in your case, Marty, glomming on something that's unlawful into the discretion context. And I think that is something we could get the AAO to review, is for them to be using juvenile convictions which the case law is clear are not convictions for immigration purposes to then deny is just wrong.
Right. However, that there is authority out there. I think there's a Second Circuit decision from 2006 that says, although an act of juvenile delinquency is not a criminal conviction on which to base removal or bar release from removal, a juvenile offense can be considered in reviewing a request for discretionary benefit. And that is the case Wallace versus Gonzalez and out of the Second Circuit in 2006. And so
if you're in the Second Circuit, you're governed by that. I mean, the one thing we do know is that So
But this is
the
also kind of
CIS
being cited by the AAO. So.
Yeah, and so, but they can only do it for Second Circuit cases. But in any event, I mean, that goes back to the do you want to explain it, even though it might be, they shouldn't be asking for it kind of thing. I want to go to Catherine's thing about the expert declaration because this is really important. I don't think you should be using therapists in general for declarations, certainly not for VAWA. For VAWAs, the very first training I went up and did, which was right after the law passed for VAWA, they said, please tell them to stop having therapists do declarations. It doesn't help us to hear that the person has PTSD. And the other thing they've said is it doesn't help us to have a counselor say she came and did group counseling and saw me 4 times. What we want is a declaration that corroborates the experience of the survivor. So you're absolutely right, Catherine, and I would stop using your therapist and start using someone who's just going to talk about what the person experienced. For you, these is a little different, right? Because you're using them to show harm. So again, you don't necessarily have to, what is it called, pathologize? That's a good word. The experience of survivors, and in fact, as we've been saying over and over, it's better not to use characterizations. It's better to use facts. So if all a therapist is going to tell you is that they're depressed, that's really not helpful. It's better to have someone, a family member that says she clearly isn't handling this very well because of blah, blah, blah. She won't walk to her car by herself. She doesn't get up in the morning when she used to, that kind of factual detail.
But that can come from a therapist. I mean, if they have that kind of relationship.
Yes, it's just that you have to train your therapist to do that because in our experience, they tend to do very kind of, DSM.
Yeah, and I think the issue is coming to the conclusion without doing the facts that establish, or kind of describe what it is. And I think that is really what is critical, is saying,
right.
and that the therapist has some kind of experience with domestic violence and can kind of make the conclusion of the diagnosis and connecting it to the nexus of the domestic violence.
Exactly. Or sexual assault or whichever.
Or whatever we're talking about, yeah.
Right, yeah. I'll read you this one still. I have a client submitted the papers. She had an interview in her country, but she was separate. That must have been an I-130 application. She had lost the evidence of the physical abuse. Okay, so if I'm reading this right, you can definitely transform an I-130 based family petition, which is the way.
But where is she? Did the abuse happen in the United States, or is the abuse still in country? I mean, because that's going to, if she's abroad, there's only certain limited circumstances in which you could file VAWA from abroad.
Or you could, I mean, it also depends on the form of abuse, right? Because if he was calling her on the phone while she was abroad, you could argue some of the abuse took place in the United States. There's actually one of the very first cases for VAWA cancellation that we did in the amicus brief, the Ninth Circuit. It's a great case. You should read it. Laura Hernandez found that the forms of abuse, like stalking and through the phone, I believe it was, counted. So in general, one of our practice pointers for you is don't assume no. If you're thinking no, contact us. I would say 75% of the time, Cecilia and I will find a way to yes for you.
I think, yeah, we can, or, so I think it depends on the facts.
Okay, and then there's this Josefina. Josefina has someone who's scheduled for a 45. You should absolutely, and I believe we have on our website, we didn't include it in here, a cover letter notifying the local office that you want to reschedule the adjustment interview and have it based on a self-petition and invoke, this is a really important law if you don't know it, 8 U.S.C. 1367, which is the protections against taking information or sharing information with abusers. And there's sanctions and monetary possible sanctions if they do that. So, Josefina, you can contact us later if you can't find it and if you need more help figuring it out. But I would do that sooner rather than later. And you don't want, the problem with, those of you familiar with domestic violence, I would say you never want your client going to an interview with their abuser, no matter how nice the abuser thinks he's being. And the way we've trained CIS on this, the local offices, is you don't want abusers showing up in your office, because they may turn against you. There's virtually, I think there's maybe been one case out of the 100 where I said you could go ahead and do it. You want to immediately transfer the basis for that to a self-petition so that there's no more relying on the abuser for anything. That's why we needed the self-petition. So what about, so yes, you can apply for VAW is the answer to that one. And the good thing is that she then applies for the kids. If the abuser was a citizen in the regular family system, the abuser would have had to apply for them. So often they will not have done that. So here's something from Margaret. Cecilia, have you seen applications for humanitarian parole for derivatives with deferred action be approved since this past January?
Maybe like one that I know of, right?
And
so, but
there haven't been a raft
I
of
think,
applications, right?
yeah, but I think that is, I think the statutory authority exists, and I think that there is a way to make an argument. And so I think that if you do decide to, we can flag it for people who we know who are paying attention to this issue. But I think the ones that I have seen approved are the ones that do have some kind of humanitarian urgency. It doesn't mean that we should stop making the argument about the significant public benefit of the U program, but the ones that have been approved is that there has been some kind of emergency.
And part of the issue for us is that very few people have actually tried what we've suggested. So that I can see no downside to trying, and between, we would ask you as the people who've both gotten this law passed and have worked for 25 years with the government on making it implement it the right way. We need you out there pushing these arguments, because especially now, there's not a whole lot we can do at the national level. We need to be doing it, as they keep saying, under the radar, where we're making the arguments on an individual basis with the adjudicators who've been there for many years. And so Cecilia softened up the parole adjudicators. They basically agreed with that we had good arguments. It's just they haven't been applying them to the few cases that have been sent in. So we need to start sending in lots of parole requests. But if you want to check with us first that you've got your T's crossed, let us know. Okay, so another
question.
Yeah.
Yeah, so she asked, what do I mean by allowing, so for the hypo that we mentioned at the beginning, what do we mean by waiting to allow the client to gain some equity? So what I mean by that is trying to get some evidence to balance the scales a little bit more. Especially if there's a conviction of shoplifting, the scale is kind of tipped in one direction because you have a recent crime that potentially, that may or may not, depending on the statute and the jurisdiction and the sentencing and all that fun stuff, may or may not be a crime of moral turpitude or might somehow qualify for an exception, but it's recent. And so the scale is kind of tipped in one direction. And so what we mean by allowing some time to gain some equities is to gain some facts or to gain some experiences that would even out the scales a little bit more by completing some kind of program or their probation, by doing some kind of classes or showing some kind of involvement in the community or with their families or with their faith organizations, to allow the client to have some time to show evidence of rehabilitation, that this is something that, particularly maybe it has a nexus to the victimization. And so maybe getting help and kind of getting a better kind of support system in place is going to be necessary to show that this is something that's not going to happen again. So what we mean by waiting is by waiting to allow the client to kind of gather enough experience or evidence to put the scales a little bit back in order.
And the factor that you can't really know is when they're actually going to open the file of your client on the wait list, right? And you do want to have, I would say, probably want to have something in there before they open the file if possible. So that's what you're juggling. Is, do I need more time to accrue equities, or are they going to open the file soon and then come back? Right?
Yeah, but if they're on the wait list, they might look at it sooner than we think, right?
Oh, yeah?
And
Okay.
so that's because I think, because if you're on the wait list, then it might be impossible because of the backlog, right? Because if we're looking at what they're processing, it's like the summer of 2014. So it might be that folks on the wait list, might be kind of covered in the next fiscal year. So if you're on the wait list and there's an issue, but we don't know. We don't know. They're coming to our conferences next year, this week. Geez.
Yeah, next week.
This week.
So maybe we'll
so maybe we'll have more information for you on the next webinar.
And I know you have to get off, Cecilia, so if you need to leave, just let me know. The
Okay.
exception to this, which you may have covered while I was struggling with my sound, is if it's a ground of inadmissibility that existed at the time you filed the U visa. And this often
Right.
happens with inherited cases, or your client didn't realize what you were asking, because that's actually a professional ethics question. You're suborning perjury if you allow them to adjudicate a case where you have not revealed a material issue, and an
Hmm.
inadmissibility ground is a material issue. So again, as soon as you figure that out, contact us and we'll help you figure out how to fix it.
Okay. And I do have to run, so thank you everyone for your questions, and thank you for being here today. And we will see you on the next webinar. Thanks so much, everyone. Thank you, Gail.
Okay, sure. I can stay on if anyone has any more questions. I'll give you a couple minutes to ask them. If not, you know how to reach us.
Mhm.
And in the future webinars, we'll probably be getting into some of this in even more detail. We often do webinars just on overcoming inadmissibility and things like that. So, okay, not seeing any chats. All right, so what do you say? Oh, Jessica, did you want to ask something? Oh, a bunch of people are typing. Okay, so, oh, thank yous. Okay, if anyone has anything to say besides thank you, we appreciate your thank yous very much. Okay. All right, I think we're going to call it a day then. We do appreciate you all participating. Again, we do apologize to those of you for whom this was too advanced. Take a look at our previous webinars and let us know if there are any gaps in the webinars we've done for OVW so far, because we do have 6 more that we're going to do in the next 6 or 7 months. And thank you very much, gals at NCJ FCJ, for hosting this for us. So, Patricia, do I just turn this off, or do you guys do that? Okay. All right. I guess we're done. Have a good day, everyone.